All right, everyone. Thank you so much for your patience. Good afternoon, everyone. My name is Jesus Scutia. I am the program manager for the Building Business Back program. We'll dive in a little bit about Building Business Back and our team. Yes, so like I mentioned, we'll be first speaking about Building Business Back and what we're doing to help Monterey County businesses. And then we'll dive right into the Corporate Transparency Act with Fenton and Keller, and we'll leave Q&A towards the end. If you do have any questions, feel free to type them into the chat box, or feel free to message me separately. So the team at Building Business Back, like I mentioned, you have myself, Jesus Gutierrez, the program manager. You have the director of operations, Paul J. Farmer, as well as the program analyst, Jose Luis Barajas. Now, a little bit about Building Business Back. So Building Business Back helps all businesses in Monterey County with a special emphasis on those belonging to historically underserved communities such as women, minority, and the LGBT plus Q plus community. Our program serves primarily as an informational hub where business owners and entrepreneurs can find and access the resources they need to be successful. Our team regularly updates our website with new grants, loans, utility, government contracting, and many other programs of interest to businesses. We also host a number of hybrid workshops throughout the county that cover a wide range of topics, including disaster relief, navigating the permit center, and getting certified as a diverse supplier. Most importantly, you can always count on assistance from one of our BPB team members. Our main office is in Salinas, but we recently added satellite office hours in several cities, including Soledad, King City, Ojaro, and Monterey. Now, a little bit as far as what we've done to help support historically underserved communities. So the one that I had mentioned initially, rural and unincorporated, we've held lunch and learns in King City and Castroville, as well as regularly participate in Cafecito with businesses in the city of Soledad. For the LGBTQ plus community, we've participated at the Salinas Valley Pride Celebration, as well as the Monterey Peninsula Pride Festival. With women-owned businesses, we've hosted workshops like the Lady Boss Women Meet Business. We've also covered workshops where diverse ownership certification towards women is a topic. And then for minorities, we've held Black Business Summits, as well as El Sueño Americano por su ITIN, where we covered a couple of topics on how you can achieve the American dream with your ITIN. Now, with us today is Tara Clemens from Fenton Keller. Tara practice focus on business transactions, estates, and civil litigation. She'll be guiding us through the ins and outs of the Corporate Transparency Act. So without further ado, the floor is yours.
And an act that is going to be affecting a lot of businesses, and yet very few people actually seem to know about the new federal. So the presentation is intended to be done first, and with regard to the new, and as we'll see, particularly exceptions to the rule, we're not able to give legal advice here for a particular situation, but certainly are happy to point to resources that people can go to for determining how the rule will apply to them specifically. So to start, let's go over a brief history of the Corporate Transparency Act. There were concerns that in the early 2000s over the lack of transparency that resulted from the formation of shell companies. And those companies could be used for money laundering, promoting terrorism, and other illegal acts. And also, most states up to that point did not previously collect detailed owner information. In 2008, first attempts to impose transparency requirements on a federal level, but it didn't get very far. To a committee and died there. Several other attempts that happened over the next 10 years. In 2017, the Transparency Act of 2017 was introduced. It was introduced in 2019, And at that time it was passed. Of a presidential veto.
Give me 1 second. The sound isn't coming through. Let's try this one. See if we can swap out. Can you hear? Try a little bit higher. Okay, I think you're good. Okay.
So basically in 2019, you have the Transparency Act, as we now know it, that did get enacted. And the enforcement of that act was delegated to the Department of Treasury, Financial Crimes Enforcement Network, or FinCEN. The Treasury regulations, and in particular, the reporting rule that we're going to talk about today, was proposed and adopted. And it is going into effect January 1st. So just here in about a month. So today we'll touch on the new requirements of the beneficial ownership information reporting rule that is going into effect. The reporting rule requires certain entities to file with the federal government beneficial ownership information reports. And that report needs to contain information about the entity itself, as well as two categories of individuals: beneficial owners and company applicants. So we'll touch on which companies are actually required to file these reports.
Hey, you guys over at the Monterey Chamber, we still can't hear you guys. Would you guys mind pausing your presentation briefly?
A reporting company is any entity that meets the definition of a company and does not qualify.
Give me 1 second. They're still having feedback issues on their end. Let me try to unmute this side. Can you hear us better now? Is that better?
We can hear you, we can't hear her.
Let me see.
So try giving her your mic instead and just turn her mic on.
No, that's fine. So FinCEN is short.
Is that better, Jose Luis? Can you hear us now?
Okay, good, because that's like I missed it.
I'd need her to talk. We can always hear you, we can't hear her.
Let me see. Sorry about that, guys. Let's
That's okay.
do.
Financial Crimes Enforcement Network. So FIN Financial Crimes Enforcement Network, CEN.
Okay.
Yeah.
Okay. It's not a workshop without technical issues, I would
That's
say.
right. That's right.
Hey, can you hear us with this mic? Is that better? Okay, perfect. I'll have her do that then. Thank you so much.
And it's so
Okay,
that mic usually is pretty good up.
yeah, so I switched it over and it should be good. So this is the one that's picking up now.
Okay.
Yeah.
Third time's the charm.
Right.
All right. So reporting companies. So reporting company is expressly any corporation and any limited liability company, and also any entity that is created by the filing of a document with a Secretary of State or an Indian tribe or a similar entity within the US. So that would be a domestic reporting company. And then a foreign reporting company is any entity that was created under foreign law but then is registered to do business within the United States. So it's a very broad definition. For California, that means that it's also going to include entities such as a limited partnership, because under California law, to form a limited partnership, you are required to file a document with the Secretary of State of California. So once you've established whether you are considered a reporting company, then you look to see, well, is there any exemption that would apply to my company? There are 23 specific types of exemptions, and we don't have time to go into all of them today. And the definitions of who meets an exemption can get pretty technical, but I do want to just touch broadly. Most of the exemptions are describing entities that are already subject to pretty extensive reporting or compliance requirements. For example, securities reporting insurer, government authority, banks, credit unions, insurance companies, and public accounting firms. Two categories that may be of particular interest to us here today are tax-exempt entities. They are considered exempt, and an entity will qualify as a tax-exempt entity if it is described under the Internal Revenue Code section 501C and is exempt from tax under section 501A. Also, if an entity meets the requirements of 501C and was exempt, but maybe has lost its exemption, but it's been less than 180 days, they still are qualify under this tax exempt entity exemption. Also, political organizations under section 527E1 and a trust under section 4947A, paragraphs 1 and 2. So again, it gets pretty technical on whether your entity is going to fall under one of those conditions for an exemption. The other category of exemption that may be of interest is with regard to inactive entities. To have that exemption apply, though, you have to meet all 6 of the criteria for that exemption. And one of those criteria is that the entity was in existence on or before January 1st, 2020. So, I mean, if you don't meet that, let's say you were formed later, the exemption automatically is not going to apply to you, even if you were to meet the remaining 5 criteria. So we've talked about what is a reporting company. As we said, the definition is extremely broad. And then also there's 23 possible exemptions, but they're very specific, and most of them apply to entities that are already subject to stringent reporting or compliance requirements. So what happens then if you are a reporting entity, reporting company, and an exemption does not apply, but you don't report, you fail to report? What happens if we don't comply? There's the potential for pretty strong repercussions for not reporting. A willful failure to report complete information with regard to the entity, and then also with regard to the beneficial owners of your entity, which we'll talk about more in a minute, or the willful provision of or attempt to provide false or fraudulent information can result in both civil and criminal penalties. So civil penalties would include a fine of up to $500 per day that the violation continues. And criminal penalties can include imprisonment for up to 2 years and or a fine of up to $10,000. Senior officers of an entity that fails to file a required report can also be held accountable for that failure. And providing false or fraudulent information can include providing copies of false identifying documents. So we'll talk about later, one of the things that you need to report or a company needs to report for their beneficial owners is a copy of a passport, a driver's license, or some other unique identifying document. If that document is fraudulent, well, you're providing fraudulent information under this act, and you could be held accountable for that. The act also talks about and addresses that an individual who qualifies as a beneficial owner but refuses to cooperate with an entity in having it fulfill its reporting requirements can also be held accountable for that under these penalties. So let's talk about who is a beneficial owner. Under the reporting rule, a beneficial owner is defined very broadly. It's not what we would necessarily think of in the business world when we hear the term beneficial owner. It is anyone who exercises substantial control over a reporting company or who owns or controls at least 25% of the ownership interest of the reporting company. So what is substantial control? An individual can be a beneficial owner through substantial control. And that is also pretty broad. So substantial control is exercised by any individual who holds a position or the authority of senior officers. So your presidents, chief financial officers, general counsel, chief executive officers, chief operating officers, a general manager, anyone who holds those positions or similar positions, irrespective of what the actual title is. If the authority is akin to what we think of with those positions or similar, then they're going to be considered to have substantial control and their information needs to be reported. Anyone who has appointment or removal authority for any of those senior positions, and anyone who's an important decision maker. So if you have someone who directs, determines, has substantial influence over important decisions regarding an entity's business or finances or its structure, they also are going to be deemed a beneficial owner. And you can exercise substantial control directly or indirectly through contracts, arrangements, and relationships. An important note for a lot of small businesses, part of the business structure is in the context of a larger estate plan. So like, for example, if you have a family business, okay, so an important note for trusts who maybe own business interests or trustees who may exercise substantial control over a reporting company, that trustee or that person with that trust may also need to be reported as a beneficial owner. The second prong for determining who is a beneficial owner is who owns or controls at least 25% of the ownership interests of the entity. So types of ownerships under the reporting rule include common to corporations, equity, stock, voting rights. With regard to limited liability companies, your capital or your profit interest, your membership interest in that LLC. It also, though, includes convertible instruments and options or privilege of buying or selling. So if you have someone who holds a convertible instrument or an option to purchase later, even if they have to pay something later or transfer something later in order to exercise that option, they're going to look at under this reporting rule as if that option had already been exercised. They're going to presume that it's exercised in determining whether they meet that 25% ownership interest mark. So that's an important thing to consider. Really, about the only time they're not looking at a potential future interest is where you have a contingent beneficiary under a trust, where the person dies and then the children are going to be inherit the ownership of the family business under the terms of the trust. If it's that remote, that contingent, they won't look at that. But again, if you've got these convertible instruments or an option to purchase, you have to take that into account in determining that 25% threshold. Okay, so, and again, another note for trusts, certain other individuals may hold ownership interests through a trust or a similar arrangement. So we talked a little bit about trustees and the substantial control they can exercise. But if the trustee or another individual has authority to dispose of the trust assets, or you have a beneficiary who is the sole permissible recipient of trust income and can demand the withdrawal of substantially all the assets, or you have a revocable trust. So you've got a grantor, a settlor who has the right to revoke and withdraw trust assets. They also are going to be considered a beneficial owner. So a couple of examples. A very simple example. We have a limited liability company. Joe is the sole owner and president of the company, makes all the important decisions for the company. Joe is going to be the beneficial owner in two different ways. Joe exercises substantial control of the company as the senior officer and owns more than 25% of the ownership interests. So Joe would have to be reported as the beneficial owner of the LLC. Let's take a little different example. You've got a corporation that has 3 shareholders. 2 of the shareholders own 90%, so one owns 50, the other owns 40. The third shareholder only owns 10%. And then you have a fourth person who is the president. So the 2 shareholders who own more than 25% and the president are all beneficial owners. They all 3 have to be reported. The third shareholder who only owns 10% doesn't exercise any substantial control, is not an officer of the company. They do not have to be reported. The analysis can become much more complicated when you start layering entities and you've got multiple entities or multiple owners owning the reporting company. So, we don't have time to go into how all of that can play out, but if you've got one entity, let's say that's owned by 2 companies, and then a shareholder who owns interest in both those companies, you have to calculate how much does that one shareholder actually own of that first reporting company. The second category of people that need to be, or individuals that need to be reported potentially, are company applicants. A domestic reporting company that was created on or after January 1st, or I should say will be created on or after January 1st, will be required to also report information on the company applicants. If the entity was created before January 1st, 2024, no need to report company applicants. All company applicants, though, must be individuals. There must be at least one, and there will be no more than 2. So the way that the FinCEN is looking at this is there's the direct filer. So the individual who directly files the document that created or registered the entity. So who was it that uploaded the articles of incorporation to the Secretary of State? That's your direct filer. And then the potential for having a second person, that is the person who directed or controlled the filing action. So who was the individual who was responsible for directing or controlling that electronic or that paper submission to the Secretary of State? It could be that they're one and the same person, so you only have to report one company applicant, but it could also be that there's 2. You have the one who's actually doing the review, and then telling maybe a staff person, okay, submit this, it's ready, good to go. Okay, so we've talked about who is a reporting company, whether there may be any exceptions that apply, and assuming that there's not, what who is a beneficial owner and who's an applicant. Okay, so now we've got that information. What information then do entities need to collect to complete the report? So there's information about the company, and then there's information about each beneficial owner, and if applicable, after January 1st, the company applicants. So for the reporting company, you'll need the full legal name. And I will say from my experience, double check what your legal name is with the Secretary of State. In my corporate transactional work, I'm constantly finding that the name in a contract that I'm reviewing or preparing doesn't quite match what's on file with the Secretary of State. And it could be as simple as leaving off the word the. So just double check that to make sure that you've got your full proper legal name that's with the Secretary of State. Okay, and then you need to include any trade name or a DBA. You need your complete current US address. So for domestic entities, that's your principal place of business. And then if you're, in the off chance that you're actually a foreign reporting company, that is, your company is actually formed outside of the US, but you're registered to do business in the US, there will be some additional information that needs to be reported. So then with each beneficial owner, and if applicable, a company applicant, you'll need their full legal name, their date of birth, their complete current address, and that is their residential street address. Okay, there's one exception to this, and that is where you have a company applicant who forms or registers the company in the ordinary course of their business. So I would run into this, for example, in my line of work. We will file or form businesses on behalf of our clients. So, I'm the one directing a staff person usually to file that. And so when it's done in the ordinary course of, for example, my business, then I would be using my business address to put in that information for me, and then also my staff person who would have been submitting that as the applicants. But otherwise, you're going to use the residential street address. And then you'll need a unique identifying number and the issuing jurisdiction for a non-expired document that's going to be accepted by FinCEN. And that is a US passport, a state-issued driver's license, or some other acceptable identification document issued by a state, local government, or tribe. If an individual who is a beneficial owner doesn't have any of those documents, then a foreign passport. FinCEN also is going to be issuing identifier numbers themselves. So an individual can get online with FinCEN after January 1st and submit their information and ask for a identifier number. And then when the entity comes, or they need to provide that information to their entity, they can simply give the FinCEN identifier number. The company can put that in the report, and that's all they have to do. But the individual would need to apply for that themselves directly with FinCEN. It's not required, but it is an option.
Who would do that?
The individual.
But why would they be motivated to do that?
Let's say they're a beneficial owner for several different entities or a few different entities. They want to keep their information to themselves, and they're like, I'm just going to submit this to FinCEN myself, and I'm not going to give it to my company, or for privacy reasons, privacy concerns. There's a number of different reasons why it may make things simpler for an individual. or more comfortable for them.
And I'm sorry, at the very beginning, because I missed the first minute, is there a minimum for a company to be required to do this, like a financial minimum?
So small entities are going to be required. One of the exceptions is a large company. And again, large is very broadly defined. There's, you have to have a certain number of employees. If I remember correctly, I think it may be like 500 and a certain financial. And again, the idea is they're likely already subject to extensive reporting and compliance requirements. So, so this is really going to affect smaller businesses. They're the ones that are going to have to reply.
And under?
Yes, there is no, there's no limitation as for size. I know there are some laws where they say you have to be a certain size before this will apply. This law is actually the reverse. So, yeah. The example I gave earlier where you've got the LLC that has one president, one owner, they have, unless there's an exception, and small size is not one of them, they're going to have to report. Yeah.
Okay, thank you.
Sure. So the next question then is, when should my company report? So if you are in existence before January 1st, 2024, though any entity that is currently existing as of that date will have a year to file their initial beneficial ownership information report. Any company or entity formed on or after January 1st, 2024 will have 30 days after they receive actual notice or public notice of its creation. Okay, so you submit your, papers, your articles to the Secretary of State. The Secretary of State sends back, the stamped, you're now formed, here's your certificate. Now you've got 30 days to file with FinCEN your initial report. Reports are going to be filed electronically online. The system is not available yet. It's supposed to be available on or after January 1st. And they're also going to be publishing instructions and technical guidance on how to complete the report form.
Coming out of what office?
This is coming out of FinCEN. So the financial, the Treasury Department. The division of the Treasury Department responsible for this.
Okay.
Yes, yes, not a problem. If you have a company that previously qualified for an exemption, but then you later cease to qualify, then the company will have 30 days from the date on which the company stopped qualifying to submit its report. Okay, so let's say you file your initial report and then later on there are changes, or you discover maybe some of the information was inaccurate. What do you do? If there's any change to the required information, then the entity must file an updated report within 30 days after the date on which the change occurred. You're not required to file changes for company applicants. So once you file that initial report naming the company applicants, your reporting requirement obligations for your applicants is fulfilled at that point. So some examples of changes to information that would require an updated filing is if you register for a new DBA or a trade name somewhere. If you have a change in your beneficial owners, so let's say you get a new CEO or a new general manager, there's a sale in your ownership interests that affects that 25% threshold, or you have the death of a beneficial owner. That's also a change that will need to eventually be reported. Now, they've given some guidance on that with regard to deaths, those changes don't need to be reported until 30 days of when the beneficial owner's estate is settled. So I mean, if someone passes away, you're not going to know all necessarily within 30 days of their date of death who the next beneficial owner is. So you do have the leeway of waiting until after their estate is settled, and then within 30 days of that, filing an update. If there's any change to a beneficial owner's name, their address, or their unique identifying number. So let's say they get a new driver's license, they move or something. Marriage, divorce, again, those can often affect, name changes. And then again, their residential street address. There is a special rule exempting the report of minor children. You don't have to report. So if you have someone who inherits ownership interest, but they're a minor, they do not need to be included in the report. But what's important to note is once that minor reaches the age of majority, they turn 18, now the company is going to be obligated to update that beneficial ownership information.
And how much time do they have once the child reaches the age of 18 for them to file?
So it's, again, that change occurs on that 18th birthday, and at least under the current rules, you'd have 30 days.
Oh, wow.
Wow.
Okay.
Okay.
Yeah.
Let's say, okay, so we've talked about if there's changes. Let's say you file your report and there's inaccuracies you find later. You have 30 days after the date that the company becomes aware of the inaccuracies or had reason to know of them. So you just need to make sure you're doing your due diligence, There is a safe harbor provision. So if you file your initial report and you find out there's inaccuracies, there's not going to be any penalties if you file your corrections within 90 days of your initial report.
Okay.
So there is that safe harbor provision.
Oh, sorry.
No worries.
So that covers the very general and very important points. Again, let's look at, we'll cover it again. Who is a reporting company? If you are required to file a paper with the Secretary of State to form your business, you are most likely a reporting company. And then you need to look and see if an exemption applies to you. Okay. If you are in existence before January 1st, 2024, you will have 1 year to file your initial report. If you form or come into existence on or after January 1st, 2024, you have 30 days. And then you just need to make sure that you've collected the information, which again is, name, address, date of birth for individuals, so that you can complete that information. We're unable, as I mentioned at the start, we're unable to cover specifically how laws may apply to individual companies or situations. So, this isn't meant to be legal advice. But if you have further questions, there's additional information available on FinCEN's website. They have a great short, small entity compliance guide that's very helpful. And then, of course, if you've got more questions specific to your situation, definitely recommend consulting with knowledgeable legal counsel to determine how this reporting rule may apply to you and your entity. So at this time, I'm more than happy to open it up for general questions.
Awesome. Thank you. Thank you so much, Tara. There was a lot of information in there. Definitely, it's a very per business or per company basis. So let's jump into questions. Let's see here. Someone's asking for the slides. Yes, I can definitely share the slides with you after the presentation today. And then someone is asking for a website where they can get more details. Well, on the current slide, if you go to fincen.gov/BOI, as Sarah mentioned, that you could find more information on there. It says, what is the entity that we need to file on? I'm assuming what is FinCEN? And I believe that question was already asked by Monica, which was,
Yeah, so this is a federal requirement, which is a little different from what we're used to with business entities. So FinCEN is actually a part of the Department of Treasury, and it's short for Financial Crimes Information Network, is what it's short for. And as far as, what entities need to file, again, it's very broad. Reporting entity is specifically mentioned a corporation, a limited liability company, so your LLCs, and then also as a catch-all, any entity that is created or registered to do business by the filing of a document with the Secretary of State or similar government agency. So in California, particularly, that's going to include your limited partnerships.
Okay.
Yeah.
And then we also have Julie asking if we could go over the requirements for trusts once more.
Okay, so trusts in and of themselves, because they come into existence not by filing with the Secretary of State, the trust itself is not a reporting entity or a reporting company. What we have to keep in mind, though, and this is where it's going to get to be more specific advice, is what does the trust own? Is their LLC or corporate ownership held by the trust? And then who has authority over that? And so that's where it gets kind of specific. We're unfortunately not able to necessarily address here, but it is something to be aware of, that even though the trustee is not the trust is not a reporting entity, a trustee or a beneficiary or a grantor or a settlor may be considered a beneficial owner of a reporting entity, and their information would need to be included in that reporting entity or that reporting company's report.
Okay. Gotcha. Let's see here. And then for those who maybe are still not 100% clear on it, what exactly, and this might be on a per company basis, but what exactly is being reported to FinCEN? What is it that the company needs to send out the information on?
Sure, yeah. So what FinCEN is looking for is they want to know who's behind the company. Again, this is to foster transparency. They want to avoid the situation of having shell entities that can foster terrorism, money laundering, and bad acts. So the information that's required to be reported, again, is, the reporting company's full legal name, any trade name or DBA, and their complete current address, US address. So what's their principal place of business? So that's for the company. And then for each beneficial owner, and if necessary, the company applicant, again, you're looking for full legal name, date of birth, and complete current residential address, and identifying documents. So that unique document that proves their identity.
Gotcha. Okay.
Can I ask, so when CalSaver was rolled out, totally different, but it was over a 3-year period, and the penalties, as I understand, were rolled out incrementally, starting with the larger down to smaller individual businesses. Do you suspect it'll be something like this, or are there penalties associated yet, or?
There are penalties.
A lot to manage.
It is a lot to manage. I have not seen anything showing, like a step up.
Okay.
They've just come out and said the penalties are up to this for the civil and criminal potential penalty.
Yeah.
So.
But there's no pecking order, I guess, that they initially stated that they're going to go from biggest.
Not that I've seen that's public yet.
Okay. Gotcha. All right, then. Well, I don't see any other questions in the chat. Might you have any other questions lingering in?
Just one quick. So as we know, the California is supportive of individual business owners. There's kind of something going on with that. That's probably going to be the residential address. which depending if they're a rent or not, will probably change. Seems a little onerous for a small business.
Yeah. Yeah, I mean, when you think about, you know, if with a really small business where your beneficial owners, maybe renters, maybe moving every 2-3
And if
years.
there's a minimum of $1 million or $500,000, 50,000, whatever it is.
Right, right. The flip side of that is that, you know, with a small entity, you've got fewer, theoretically, you have fewer beneficial owners to keep track of. So because your LLC, you know, and the person who is owning the LLC, running the LLC is likely 1, 2, maybe 3 people, you're gonna know if something changes and you need to update that report. But yeah, it is an extra layer of your governance in terms of making sure that this information stays updated with the Department of Treasury.
And IRS falls under treasurer.
Yeah. Yeah, this information, and which raises another issue, is so the information that's being reported is not available to the public. It's not in a searchable database. Like right now we can search Secretary of State, you know, and come up with names and things. That this information will not be available like that. It will be available though for law enforcement purposes, naturally.
Yeah.
So certain law enforcement agencies, and then also some financial institutions may have access to this information as well to help them with their compliance and meet their obligations. So, yeah.
Okay.
Do financial institutions have to know about this? Like,
They're one of the exceptions because they're already subject to regulation. Yeah.
We have Tanya Santos with us on Zoom that is going to ask her question live. Go ahead, Tanya.
Yes, can you hear me?
Or give me 1 second. Let me see if I can.
Can you hear me?
Are you there? Can you hear us now, or can?
Yes, I can hear you.
I can hear you, Tanya. Yeah.
Oh, okay. All right. So I am still a little confused. I am a tax professional, but I am confused about the reporting. You know, people are going to be, I understand they can do it on their own, but I also know that they're going to seek professional help. So is this something that mainly tax
Give me 1
professionals?
second, Tanya. We can
Okay.
barely hear you.
Let me see, maybe I can, give me my mic. Audio settings. Let
Okay.
me change my.
To adjust the audio output.
Can you-
rather than-
We can hear you now.
Okay, there. So I understand that individuals can do this on their own, but I also know that they're going to seek for professional help. So will this be something that mainly tax professionals will be doing, or is this more a legal reporting item?
Yeah, great question. You may have tax professionals or company advisors that may be familiar with this, but this really is more legal. It's more on the legal side. So, you know, it's certainly, if you need the advice and guidance, it's, you know, it's worth asking, but knowing whether you meet the legal definitions, legal requirements, you know, do you meet the legal definition for an exemption? That's really going to be more of your legal professional that's going to be able to answer those questions.
Yeah, because I see this, I see a lot of colleagues, you know, tax colleagues that are promoting this a lot. And but I just don't see any numbers, I just don't see any tax
Right,
thing
yeah.
in there. I think it's more legal, so I'm just wondering, because I know a lot of taxpayers will be concerned and they will want us, the tax professionals, to do it. And there's always a confusion there.
Yeah.
So I just wanted to know if it was okay for a tax professional to do it, or if it was, yeah. So that was my main question.
Okay, yeah, and that's a little different question in terms of advising the tax professional and what you can do within the scope of your work. And kind of outside the scope of what we're here for today. But yeah, it definitely is something that I will be doing for my clients in terms of, walking them through their governance and reporting obligations. So.
But it's also something they can do on their own, right?
Yeah, absolutely. I mean, it's not like they can't do it on their own. As I said, and provided the website at the end of the presentation. FinCEN has, really great resources, at their website, including a small entity compliance guide. But I can definitely see how there may still be some questions and some concerns in how this actually applies to an individual situation. So, to really be certain, if you, put your mind at ease, or you have a client, they want to put their mind at ease, it doesn't hurt to contact their legal professional just to make sure with their situation, what are they obligated to do?
Thank you.
My pleasure.
Perfect.
Thank you.
Thank you, Tanya, for that question. Alrighty then, I don't see any other questions in the chat. If anyone does, please feel free to place them in now. But if not, I just want to take some time to thank everyone for being part of this workshop today, participating. A lot of great questions, a lot of great information. Thank you so much, Sarah, for this. We were having a conversation beforehand. So much of this, so many people do not know what's going on at the beginning of 2024. And it's definitely something that everyone needs to know, especially if they have a company or are considering, especially with the time restraints, considering becoming a corporation in the first quarter of 2024. And with that, I'd also like to thank the Monterey Peninsula Chamber of Commerce for letting us host our workshop here today. They're always a great partner to have. And I'd also like to thank Monterey County for setting aside money for building business back. The workshop today is free because they were able to set aside funds for the ARPA Foundation. So thank you so much for participating. That will be the end of our workshop, and have happy holidays.
Thank you, everyone.
Thank you.